How does a single 30-page civil lawsuit filed on a quiet Tuesday in New York trigger a massive multi-state federal raid just a few months later?
It's a staggering escalation, really.
It is. Today, we're looking at the math behind the legal scrutiny of an empire. So, on the morning of March 25, 2024, federal agents from Homeland Security Investigations arrived at properties connected to Sean Combs.
And there's no cinematic shout, right? No sudden drama.
None at all. It was just the quiet, mechanical reality of law enforcement executing search warrants. But that quiet moment shifted the control of a massive narrative entirely out of the global news cycle and directly into the hands of federal investigators.
Which is precisely why we need to examine how we got to that morning. I mean, the sheer volume of noise surrounding this event makes it incredibly difficult to understand the actual mechanics of what is happening.
Yeah, the social media roar is just deafening right now.
Exactly. We are dealing with an incredibly complex, ongoing federal inquiry running parallel to a whole cascade of civil lawsuits.
And our mission today is to cut through that noise for you. You need a factual, objective timeline of a developing legal story without all the speculation.
But before we delve into any of the timeline or the mechanisms, we really have to establish the strict boundary for this conversation. Today, we are relying entirely on public legal filings and verified investigative reporting.
Right. Just the paper trail.
Just the paper trail. Everything we discuss regarding Sean Combs exists strictly at the level of allegation. No criminal charges have been filed. The claims made in these civil suits remain completely unproven in a court of law.
The presumption of innocence is paramount here.
It's the functional bedrock of the justice system we're about to analyze.
Okay, let's unpack this not as a cultural event, but as an active legal matrix. Because you cannot look at this investigation without first understanding the scale of the operation that was built over the last 30 years.
Right, we aren't just talking about a musician.
Not at all. We are talking about a network of access. Bad Boy Records, the clothing line Sean John, the Spirits deals with C-Rock, Revolt TV.
It's a massive corporate footprint.
Exactly. This level of wealth generates a specific kind of environment. It grants access to exclusive recording studios, corporate boardrooms, high-level political circles.
When you construct an operation of that magnitude, you're employing hundreds of people. You're managing dozens of properties and operating across multiple state and international lines.
You essentially create an environment of immense influence.
You do. But the inherent tension there is that every room you operate in and every contract you sign leaves a paper trail. And the first major legal filing that challenged that environment happened in November of 2023.
Right, that was November 16th. Cassandra Ventura, known professionally as Cassie, files a lawsuit in a New York federal court. And I read through the reporting on this, and what struck me was the sheer density of it.
It wasn't a vague complaint.
No, not at all. It was over 30 pages detailing gravely serious allegations. Years of physical abuse, sexual assault, and coercive control. It outlined a power dynamic allegedly designed to restrict her personal freedom.
And legally speaking, the specificity is what matters there. The complaint named dates, described specific locations, and alleged a systemic method of operation.
It was a narrative that legally invited immediate, rigorous scrutiny.
It did, but then...
Within 24 hours, the entire lawsuit is settled privately.
Right.
There is no trial, no discovery phase, and crucially, no admission of liability from Combs. Now, I understand that historically, an immediate, undisclosed settlement is designed to put a lid on a scandal.
It's the standard corporate crisis maneuver.
Yeah, it's supposed to be like throwing a heavy blanket over a fire, but here, instead of extinguishing the flame, the settlement seemed to just force the smoke into every other room of the house.
That's a very apt way to put it.
So why didn't the settlement work the way it usually does in these high-stakes disputes?
Because of the mechanics of modern digital litigation.
Yeah.
In the past, a rapid settlement meant the details of a lawsuit might never reach the broader public consciousness. It would just disappear into a filing cabinet.
Out of sight, out of mind.
Exactly. But today, court documents are filed electronically on systems like Pacer. So within minutes of Ventura's filing, that 30-page document was downloaded, distributed, and archived by journalists and the public.
So the narrative was already out there.
Yes. A settlement signed 24 hours later resolves the financial dispute between the two parties, but it does absolutely nothing to erase the narrative from the public domain.
If anything, it seemed to amplify it.
Precisely. Settling so quickly, for many observers, simply signaled that the initial barrier of silence had been successfully breached.
And that breach clearly acted as a signal. Because in the weeks following the Ventura settlement, we saw multiple individuals file their own civil complaints against Combs.
Bringing similar, highly severe allegations.
Right. They alleged sexual assault, and several alleged they were coerced into sexual acts under the explicit promise of career advancement. And you might be wondering why some of these lawsuits were filed without names attached.
The John Doe or Jane Doe filings.
Exactly. I know U.S. civil procedure has specific allowances for those kinds of anonymous filings to protect individuals in cases involving alleged sexual violence. It shields them from immediate public retaliation while their claims are processed.
And that protection is absolutely vital. But the accumulation of these suits triggers something much larger. When you have one civil lawsuit, the legal system views it as an isolated dispute between two private parties.
Just a localized issue.
Right. But when you have 3, 4, or 5 lawsuits spanning different years but detailing highly similar alleged methods of operation, plaintiff attorneys begin constructing what is known in civil law as a mosaic.
A mosaic. I want to push on that. I understand how civil suits work. It's private attorneys fighting over financial liability.
Yes.
But how do isolated civil claims written on paper suddenly bridge the gap to federal agents knocking on doors at dawn? I mean, does a federal judge just read the news and decide to call Homeland Security?
What's fascinating here is how the mosaic actually forces a jurisdictional shift. A federal agency doesn't act on rumors, but they absolutely do monitor public courts dockets.
So they're watching these filings pile up.
Exactly. When multiple civil suits allege that a defendant used corporate resources, private jets, and interstate wire transfers to facilitate alleged misconduct, it ceases to be a localized personal injury claim.
It becomes a federal issue.
Yes, it begins to look like a potential pattern of interstate commerce being used for illicit purposes.
Yeah.
That sheer volume and the alleged structural pattern is what captures federal attention.
Which brings us to the specifics of the March 2024 raids. The agency executing those warrants was Homeland Security Investigations, or HSI.
Right.
And when I first saw the headlines, I was confused. Why Homeland Security? If it's a high-profile investigation involving an American citizen in Los Angeles and Miami, why isn't the FBI handling this?
It is a really common misconception that the FBI handles all federal inquiries. HSI is actually the primary investigative arm of the Department of Homeland Security.
Oh, interesting. So what is their specific jurisdiction?
Their mandate covers transnational crime, financial crimes across borders, human smuggling, and exploitation cases. Because Combs' business operations and personal travel allegedly involve extensive international and cross-border movement, HSI has the specific jurisdictional authority to investigate.
And the specialized forensic units for those pathways, I assume.
Exactly.
And the background reporting from major news outlets indicates this inquiry involves potential violations of the Mann Act. Now, I looked this up, and it's a federal statute from 1910.
Yes, it's quite old.
So how does a law meant for the steam engine era apply to a modern music mogul?
Well, the Mann Act fundamentally deals with the transportation of individuals across state lines for illegal sexual activity.
Oh.
While it was written over a century ago, its application is highly relevant in the modern era of private aviation and digital coordination.
So the technology changed, but the core alleged act is the same.
Precisely. If an investigation is looking into allegations that a network was used to fly individuals across state jurisdictions for coercive purposes, the Mann Act is the precise federal statute that governs that alleged activity.
That makes the stakes incredibly high. But let me play the role of the skeptical public for a second here.
Please do.
If federal agents show up in tactical gear, put up crime scene tape around your property, and walk out with boxes of your hard drives and mobile phones, hasn't the government basically decided you're guilty?
That's a very common leap to make.
Right, because they wouldn't raid multiple mansions just on a hunch. Why wasn't there a formal charge the very next day?
That is one of the most dangerous, though understandable assumptions people make about the criminal justice system. We have to clearly delineate the structural gap between a search warrant and an indictment. They are entirely different legal universes.
I assume a search warrant just means they convince a judge they need to look around.
Exactly. To secure a search warrant, federal prosecutors only need to demonstrate probable cause.
And what does that mean practically?
Probable cause is a relatively low bar. It simply means there is a reasonable factual basis to believe that evidence of a crime might be found at that specific location. It is strictly an investigative tool.
So it's not a conviction?
It is not a conviction. It does not even mean the government has enough evidence to officially charge the person. When HSI seizes a hard drive, they are looking for metadata, geolocation pings, financial transaction trails, and encrypted communications.
Which I imagine takes a massive amount of time to sort through.
Oh, digital forensics take months, sometimes years, to properly image and analyze.
And while that forensic analysis is happening in a lab somewhere, the defense is actively pushing back. We need to be very clear about the counterweight here.
Yes, the defense's position is critical to the public record.
Sean Combs's legal team has vehemently and categorically denied all allegations across the board. They have dismissed the civil lawsuits as meritless.
And regarding the settlement, they've continuously emphasized that settling a civil suit is a business decision, not an admission of guilt.
Right. And they have publicly stated their absolute confidence that this federal investigation will ultimately clear his name. That defense is an active, permanent part of the legal record.
Furthermore, a defense attorney doesn't just sit back during this period. Remember the mosaic we discussed earlier?
Yeah, the pattern of civil suits.
Right. The defense's job is to dismantle that mosaic. They don't try to attack the entire picture at once. They go after the individual tiles.
How do they do that?
They will look at each civil claim and challenge the statute of limitations, question the credibility or financial motivations of the plaintiffs, and argue that the events described were entirely consensual.
But because the federal system demands such a rigorous, methodical approach to analyzing evidence and securing an indictment, it creates this massive, agonizing waiting period. There is a total vacuum of official information.
And social media immediately floods into that vacuum with its own unregulated form of litigation.
If we connect this to the bigger picture, we are witnessing the complete inversion of the traditional investigative timeline.
Yes, the old model was highly linear. A complaint is filed privately, law enforcement spends 2 years quietly investigating, and then, only if the evidence permits an indictment, the public is informed.
The public usually learn the details by observing a formal trial. You essentially learn the story in retrospect after the professionals had already vetted the facts.
Yes, but today, the timeline is completely upside down. Lawsuits are posted online within minutes. Hashtags trend instantly.
Everyone's an expert all of a sudden.
Exactly. Commentary creators on platforms like YouTube and TikTok act as instant judges, meticulously dissecting unproven legal documents before a defendant has even had time to retain proper counsel, let alone issue a formal public statement.
It reminds me of a crowded stadium where tens of thousands of fans are screaming out the final score, dissecting every supposed play. But the teams haven't even suited up or taken the field yet. The game hasn't actually started.
That is a highly accurate visualization, and it highlights the intense friction between digital witness and due process. The court of public opinion forms rapid, concrete conclusions based on fragments of unproven claims.
It operates on pure emotion and speed.
It does, but the actual court of law operates on a completely different, almost diametrically opposed logic.
Because the law demands strict evidentiary standards. You can't just submit a trending video as proof of a federal crime.
Precisely. The federal system demands cross-examination. It demands that evidence be legally obtained. Grand jury proceedings, by law, must remain entirely sealed to protect the integrity of the investigation and the privacy of the accused.
So if prosecutors mess up,
If federal prosecutors make a single procedural misstep, if they mishandle a piece of digital evidence or violate a defendant's rights during a raid, they can completely compromise the viability of a future trial.
so due process moves agonizingly slowly by design.
Yes, because the ultimate stakes involve the potential deprivation of a citizen's liberty.
Which naturally forces us to look beyond just the procedural mechanics of the law and examine the broader entertainment ecosystem that surrounds cases like this.
It's a vital part of the context.
Right. When I read the commentary and the analysis from legal scholars about this case, the intense public reaction isn't just about one specific mogul. It feels like a broader reaction to the alleged structural systems that allow powerful figures across the industry to operate without immediate accountability.
We are seeing this framed within the larger reckonings of the music and entertainment industries over the past decade. Legal analysts are comparing the structural questions raised here to the complexities of the R. Kelly case or the systemic issues exposed at major film studios.
The public is no longer just asking what happened. They are asking what systems make this environment possible.
Exactly. We're talking about the alleged sub-architecture of the entertainment business itself.
The off-the-record private gatherings, the cultures of silence within corporate suites, and the deliberate blurring of professional opportunity with personal exploitation.
And at the center of that sub-architecture is often a very specific legal mechanism, the non-disclosure agreement, or NDA.
I want to focus on that. So, what does this all mean when we talk about NDAs? How does an NDA actually function in this context? Is it just a legal gag order?
Well, it's complicated.
Because when you look at the scale of a massive entertainment empire, the true product isn't just the music or the vodka brand. The true product is the manufacturing of environments, environments of absolute exclusivity. And that makes the allegations of a power imbalance so deeply structural.
An NDA, at its core, is a legitimate contract designed to protect trade secrets and proprietary business information. Like if you work for a tech company, you sign an NDA so you don't take their code to a competitor.
That makes sense.
But in the entertainment industry, NDAs have frequently been utilized as sweeping behavioral catch-alls. They are presented to individuals entering private parties, recording sessions, or personal employment.
Can they actually cover up illegal acts?
No. An NDA generally cannot be legally enforced to cover up a felony crime. But the sheer threat of ruinous financial litigation is often enough to enforce a profound culture of silence.
So even if the NDA wouldn't hold up in court if a crime was committed, the person signing it, who might not have high-priced lawyers of their own, is terrified of being sued into bankruptcy just for speaking out.
Exactly. The mechanism is fear of litigation, not necessarily the legal enforceability of the contract itself. It allegedly allows powerful entities to isolate incidents and prevent a pattern of behavior from ever becoming public.
It isolates the individual tiles so they never form a mosaic.
That's the exact legal strategy. But again, I must ground this conversation in our established reality. While legal analysts are rightly asking profound questions about the industry's complicity in the use of these contracts, it is vital to remember that regarding Sean Combs specifically, the application of these systems remains an open question.
These are allegations of how his business is operated. They are not findings of fact. Which brings us back to the reality of the public record as it stands today. Let's concisely recap the factual matrix we are looking at for you, the listener.
We currently have multiple active civil lawsuits alleging severe physical and sexual misconduct.
We have a confirmed, highly visible federal investigation being conducted by Homeland Security Investigations, marked by physical search warrants and digital forensics.
We have categorical, vehement denials of all allegations from the defense team.
And we have absolutely zero federal criminal charges filed. The process we are watching is slow, it is highly adversarial, and it is entirely incomplete.
And as an observer of this process, you really have to acknowledge the difficulty of that reality. In an age built on instant gratification and 24-hour news cycles, waiting for the legal system to work feels like a kind of deprivation.
We are socially conditioned to demand a verdict right now.
But you are being asked to do something very difficult and very necessary as a consumer of this information. You are being asked to hold two conflicting truths simultaneously.
On one hand, you have to respect the extreme gravity of these serious civil allegations, recognizing the significant bravery it takes for individuals to step forward and place their names on federal court dockets.
And on the other hand, you must strictly uphold the subject's fundamental right to the presumption of innocence. You must acknowledge the defense's right to challenge every single claim until it is proven guilty in a court of law beyond a reasonable doubt.
Both of those truths must be held at the exact same time.
The story remains a mechanism in motion. It's still open, still under investigation, and still completely unresolved.
It leaves us with a broader, lingering thought, something for you to really mull over as this federal process slowly grinds forward behind closed doors. We've spent time analyzing that sub-architecture of the industry today.
The NDAs,
Uh-huh.
the cultures of access.
Exactly.